Welcome to Team 2's presentation. First off, I want to thank Clint Green, who is not here, but he's the one who made the arrangements for the Westwood Club, and thank you, Westwood Club, for allowing us to be here. I want to thank Hunton & Williams, which is it's a small firm. It used to be a solo practice. And you guys probably know Hunton & Williams. They got together, and they've got a couple branches here and there, but they are our sponsor for tonight, so thank you to Hunton & Williams. And tonight's program is about professional integrity in the practice of law, and it's my great privilege to have Jim Thomas here. He has come all the way up from Athens, Georgia. He happens to be Ashley Tunner's cousin, so that's how we were able to convince him to come up. In his book, Integrity, Professor Stephen L. Carter of the Harvard Law School wrote that professional integrity is the crown jewel of the American judicial system, and I think we would all probably agree with that statement. Mr. Thomas is here to speak on that topic. He was educated at the University of Georgia, at Emory Law School, and at Harvard University. He has had more than 100 civil jury trials. He holds the highest verdict for you plaintiffs' lawyers out there in Lawrence County, Georgia, and is formerly of the firm Bowen, Williams, and Levy, and you may have heard of this firm. It's the firm that is the defense firm in the movie and the book Midnight in the Garden of Good and Evil. And Jim will deny it, but I'm quite sure he was involved in several of those trials. You may recall there were 4 trials, and ultimately I think Mr. Williams, who was the defendant, was set free in that case. Jim practiced up until being retained in a Quietam case. I hope I said that the right way. I think it's a whistleblower case. And after the whistleblower case, he was able to retire, which is something I know many of us aspire to do. He's published many articles and books. His 1994 book, Persuasive Speech, is a good read for everybody. And please give a warm welcome to Mr. Jim Thomas. Thank you, Jim.
Attorney Tunner, President Davis, and members and guests of the Lewis Powell Inn of Court. I commend the inn for its name, for few American lawyers have reached the levels of achievement and distinction as did Lewis F. Powell, Jr. Regrettably, one of his finest accomplishments is often overlooked, and it's of critical importance. While an undergraduate at Washington Lee, he was recognized as the best dancer on campus. Integrity is a derivative from the French, and it first appeared in English about 1420. Gutenberg was yet to perfect the printing press. The reading public was minuscule, and the word was scarcely seen or heard. In the second decade of the 21st century, it comes at us from all points on the compass, depicting both the personal and the impersonal. And any consideration of it carries us over and beyond the everyday honorable virtues of courtesy or patience or the good missionary's sense of charity. She was walking home from her place of employment in New York late one summer afternoon when she passed a homeless man squatting on the street. He was unwashed, raggedly attired, and in bad shape all around. When she got home, she found that someone had stuck in her door an envelope. It had secret blessings on it, and it contained a single $20 bill. Giving the matter further thought, she told her roommate that she was going to give that $20 bill to the homeless man that she saw on the street. So she went back down and found him. He had moved, but he took the envelope without saying a word. The next afternoon, when she got home, he appeared at her door, knocked on the door, and handed her the same envelope. It contained 6 $20 bills. He said, "Ma'am, your horse secret blessings paid 6-1 at the track." Now, we can all use charity, but when it comes to this inexhaustible virtue, we bring to the fore a primary wisdom and it was formulated across a succession of centuries and passed down to us as a legacy of upright conduct. At the bench and bar, the word resonates. A gospel of the law is how Professor Carter up at Harvard puts it. Chief Justice Warren Burger was once asked the qualifications for serving on the U.S. Supreme Court, and he said there aren't but three: intelligence, competence, and integrity. Irrespective of what might have been said or written, advertised or joked about, professional integrity stands rigidly before the bar as one of its indispensable elements, and the organized bar both mandates and imposes it. The word frequently appears in bar handbooks, in codes of ethics, and standards of professional behavior. For example, in the case of N. Ray Jenkins, the Georgia Supreme Court said this, that the relation of courts and attorneys is one of high responsibility, involving complete trust and confidence and absolute fidelity to integrity. For the most part, the standards imposed by the bar are prohibitive in nature. They contain the great thou shalt nots, by and large, with some exceptions. Necessary and essential, of course. And standards of professional integrity, however, have a second equally significant source, and those are the standards imposed by the practitioner himself or herself. They are the values and the convictions and the ideas and the ideals that fix how one practices law, as distinguished from what one practices. And in turn, the how of law practice directly affects success in the legal marketplace, and that marketplace has become more challenging than ever. For consideration, 4 succinct points. Now, don't despair. I'm going to get you out of here before midnight. Number 1, the lawyer's product line, commercial metaphor notwithstanding, the bona fide meaning of practice with integrity, its benefits and payoffs, and last, a very few governing tenets. It's widely held among younger lawyers in particular, and less experienced practitioners, this postulate that legal proficiency is enough. Skills in research and writing, negotiation and organization, insight in solving intricate legal problems, as dynamite advocates at the trial and appellate levels, this postulate holds, pave the way to business development. And yes, they are and should be the essential skills of all lawyers, and today's well-trained attorneys with their magical technology are very good at them. But there's another necessary party to be considered, the client. And what does he have to say? For him, counsel's competence and expertise are largely presumed. The time-strapped clients of today have neither the time nor the inclination to probe into the attorney's skills and expertise. And moreover, very few clients recognize a clever court filing from a poor one. Additionally, the value of legal services, ladies and gentlemen, is a given. And by value, I mean the built-ins of legal services. And comprising value are a legal education, a license, training, expertise perhaps in a given specialty. And undoubtedly, value is a prerequisite of professional survival. Many years ago in Paris, a well-to-do lady from America was strolling along the street when she came across Pablo Picasso sketching at a sidewalk cafe. And thrilled at the prospect, she approached the artist and asked him if he would sketch her and charge her accordingly. And of course he agreed. and in a matter of minutes, the lady was holding in her hands an original Picasso. She said, "What do I owe you?" He said, 5,000 francs. She said, "But sir, it only took you a few minutes." He said, "No, ma'am. It took me all my life." You see, Picasso fully comprehended his innate value as an American law, as a painter, and it's important that American lawyers, I'll get this right in a moment, understand their innate values as well. Think about it. A lawyer's service is an unwarranted promise. He warrants neither the substance nor the results to be achieved. When the client engages the counsel, the client owns nothing. He holds a naked promise that the lawyer will perform a service as only an American lawyer can, that and nothing more. I respectfully submit that a professional relationship, that is the American lawyer's product line. And in the everyday, workaday world of the law, what counts in the end is the client's overall experience in working with the lawyer or his firm. Harry Beckwith of Minneapolis is one of the leading authorities in the country on marketing of services. His book, Selling the Invisible, has become a Bible. And he maintains that the key to long-term success in professional relationships is the integrity behind the name. That the name is analogous to a brand, an unspoken promise that performance will measure up to the name's reputation. Beckwith's advice is invest in integrity. That brings us to point 2. For Beckwith's admonition calls for a definition. Intuitively, lawyers know what integrity means. For they expect it from other lawyers, they expect it from adversaries, just as their clients, the courts, and other lawyers expect it of them. And yet, amidst the pressures and demands of modern practice, a definition is hard to come by. And similarly, few pause to specify its bona fide payoffs and benefits. It's something of an oddity that this holds true in the legal literature itself. Cyrus Vance was an outstanding lawyer and a pillar of the bar of the city of New York. He was appointed Secretary of State in the Carter administration. And in 1980, he resigned that prestigious post on grounds that he could no longer agree with the administration's policies regarding Iran. A columnist in the Washington Post said, "You can put Vance's name next to the dictionary definition of integrity." But if you look, Mr. Webster is a limited help in illuminating this inexhaustible virtue, and many contend that it ranks first among all of man's great cardinal virtues. In the abstract, it's pregnant with meaning and nuance, hard to get a handle on. But when we see it, we know it. Brooksley Bourne was a partner in the Washington, D.C. firm of Arnold and Porter. Her specialty was in securities arbitration and litigation. And by the way, she was the first woman to serve as editor of the Stanford Law Review. On August 26, 1996, President Clinton appointed her as chairperson of the Commodities, Futures, and Trading Commission. The CFTC is a tiny agency that oversees the futures and commodity options market. And it came to her attention that a new market was emerging. It was expanding and morphing into a juggernaut, the $27 trillion over-the-counter derivatives market, and the bulk of its trading was in subprime mortgage-backed securities. Known as a dark market, it was totally unregulated. And Bourne became convinced that this market was wide open for abuse and badly in need of some governmental oversight. So, as lawyers often do, she had a choice. She could remain silent and do nothing. There was nothing in the laws or the regulations of the CFTC that required her to do anything in the way of offering remedial action. Or she could speak out, sound the alarm, and seek some reform. And after many sleepless nights, she chose the latter course. And her voice proved to be the singular authoritative voice throughout the vast federal bureaucracy, sounding warnings about the derivatives market. She met with the highest officials in the government with authority to act more than once. She presented her findings, she expressed her concerns, she submitted proposals for legislative language, and her warnings were blandished and squelched. And when she published her proposals, Congress, too, turned its head, and when that happened, Brooksley Bourne resigned her chair position at the CFTC, and by, we know what happened. The Great Recession came, and one of the chief culprits was the dark market trading in the lowly house mortgage. In 2009, she received the John F. Kennedy Profile and Courage Award, and the commendation read, "An appreciation of a far-sighted public servant who acted on principle to protect the public interest." Bourne demonstrated integrity in action, and here are the silent underpinnings. The virtue radiates an adhesion. It means a rigid adherence to principles and convictions and beliefs and standards that withstand the sharpest scrutiny and that to some extent, in some fashion, are beneficial. When you pare it down to its bedrock essence, integrity is the capacity to stand by the right ideas even when it is difficult, inconvenient, or unprofitable. Albert Camus, a hero of the French Resistance and winner of the Nobel Prize in Literature, said that if you have integrity, you don't even need the rules. The law firm of Cravath, Swaine, and Moore in New York City was and is one of the nation's premier firms. One or more of its founders served in the administration of Abraham Lincoln, and for years it had represented the Rockefeller interests. Nelson Rockefeller was governor of New York from 1959 to 1973. In 1962, he became involved in a high-profile divorce proceeding with his spouse of 32 years. There were 5 children involved in vast wealth, and Cravath represented the governor. When the case closed, the firm submitted its final statement. The governor received it and reviewed it. And if you can believe it, he considered it inadequate, that their services were worth more than what they were charging him. He called the firm and asked that it submit a revised statement and a higher fee. The Cravath lawyers called back and said, "Governor, our statement as submitted fully compensates us for services rendered. It stands as submitted." You see any integrity there? On which end? Integrity is about making a premeditated choice. The practitioner adopts one alternative and discards the other, just as Cravath faced the choice of raising its fee at the request of the client or letting it stand. In law practice, difficult choices come with amazing frequency. And no authority says that counsel must always make the superior choice, but it's imperative that counsel avoid making the wrong choices. In his highly popular book, Your Greatest Power, psychologist J. Martin Coe contends that the power to choose is the greatest single power in the human psyche. Invariably, integrity deals with choosing the right thing at the right time for the right reasons. And just as Potter Stewart said, there is a difference between what you have a right to do and the right thing to do. And the American bar is populated with lawyers whose practices are standing monuments of professional integrity. And here, and I need not tell you, you already know these things, it's what it looks like up close. They place a heavy premium on trustworthiness, reliability, and reputation, their precious reputations. They know that how they practice is as obligatory as what they practice. Their word is their bond, and they keep it in matters great and small. They strive to deliver their services as promised, when promised, in the manner promised. And when working on demanding and difficult problems, expediency is not an option. They refuse to cut corners or play fast and loose with the rules or the spirit of the rules. They have a keen sense of sin. They look with disdain on the unfair advantage, and they practice scrupulous honesty. Sometimes the price tag is high because holding fast to a principle can cause the loss of a client. Even the case, it can disrupt firms and partnerships, impair career advancement, and induce grief and render one unpopular. Point 3, the payoffs, and this is a short one. Ben W. Heinemann was a former general counsel and vice president of General Electric. He's now on the staff at Harvard Law School, and he teaches that practice with integrity yields these returns: stronger professional relationships, loyal clients, business and client referrals, dedicated staffs and employees, a magnification of the practitioner's name, that of the firm, the group, the partnership, higher leadership possibilities at the bar, and enhanced credibility with clients and prospective clients, courts and adversaries, colleagues and associates. Third and last, 3 very brief tenets. Now, there are others, but these are among the firm foundation. And the first tenet is an allegiance to the truth, the clear, unmistakable, unvarnished, sometimes haggard truth. Counsel's deliberate choice must stand firmly on what is the truth. And every trade or profession or calling the world over places truth as a supreme value, and even though universally practiced, the fabrication is also universally condemned. And I'm not speaking of Miss Lillian Carter's little white lies. She was the mother of former President Jimmy Carter, and he enjoys recalling an incident that occurred during his presence. Lillian Carter was an extraordinary and remarkable woman, a woman of very strong opinions, which she readily expressed. And shortly after Jimmy Carter's election, Lillian appeared on the scene with her voice and opinions, and of course the media had to have an interview. She refused for a long time, but she finally agreed. So the president said, I briefed Mother, be careful with what you say in this interview, because your words could be taken out of context. You could find yourself on national television. She said, son, I fully understand. So the interview was set up, and the journalist appeared at Lillian's home in Plains, Georgia, and she met him at the front door and said, welcome to my home, come on in. And he did. And he asked her during the interview, now, Miss Carter, "Did your son ever lie to you?" Lillian said, "No, he never lied to me." And he became somewhat aggressive. He said, "Look here, Miss Carter, every little boy lies to his mother." Lillian said, "Well, he may have told me a white lie." And the reporter said, the journalist said, "Now, Miss Carter, what just do you mean by a white lie?" And she said, "Well, a good example of a white lie would be when I told you you were welcome in my house." One of my law partners at the firm of Bowen, Williams, and Levy in Savannah was a former naval officer. He had a practice in maritime law. And sometime in the 1980s, on a date I wish I had recorded, his closest friend found himself in some very difficult circumstances, and there was talk of both criminal and civil liabilities. And Ed asked several of us to meet with him in his office to talk about it. I do not recall all that was said that morning, but I do remember this. He said, "You know, I would do anything I could do to help my friend, but I will not lie for him, for anybody else, or about anything else." Yes, we would expect that of a lawyer. But to hear Rob's allegiance to the truth, irrespective of a very deep friendship, reinforced my respect for him and concurrently fostered belief in those practical imperatives that are noble and enduring, those that embody professional integrity in its clearest light. Harry Beckwith, who I quoted earlier, said that trust is the key to the sale of services, and truth is the basis of trust. So always tell the truth. Regardless of what you do, tell the truth, for even when it hurts, it will help. I trust you get the drift. Tenet 2 is a readiness to declare what one's convictions and principles, ideas and ideals are. And in the great scheme of things, they have no effect unless they are declared, for otherwise they rise precisely to the level of self-indulgence. Lest we forget that silence can install a statement of consent, an agreement with that with which we inwardly disagree. In an oft-quoted statement, Martin Luther King said that the ultimate measure of the person is not found in moments in comfort and convenience, but in those inescapable moments of challenge and controversy. And in the snow-covered streets of Boston in March of 1770, British soldiers faced a very rowdy crowd. It became very dangerous. They opened fire, killing 5 civilians. And this well-known historic event became known as the Boston Massacre, and it outraged colonists from Vermont to Georgia. A lesser-known fact is that no lawyer in Boston would take the defense of the British soldiers. And in the climate of the times, the risk was obvious. That is, no lawyer save one. 34-year-old attorney John Adams in Boston had one of the best law practices in colonial America. He had the most to lose. And yet it was he who agreed to defend the British soldiers. And in doing so, he declared one of his deepest convictions, that no man in a free country should be denied the right of counsel and a fair trial. In law practice, they crop up with regularity, these issues of consequence, material questions demanding answers, complex problems requiring solutions, and when they do, who extols the hedge or the sidestep, the straddle or the waffle? An admiring colleague who did not always agree with him said of Chief Justice Earl Warren, former governor of the state of California and later Chief Justice, that Warren stood up and was counted on every great issue of his age. Have you ever paused and pondered the question, where in my day-to-day law practice do I refuse to yield? On what principles am I non-negotiable? This is the third and last tenet. Now, if you'll stay with me just a little bit longer, I'm going to finish up. As Elizabeth Taylor told her 8 husbands, I'm not going to hold you much longer. Tenet 3 says that one must cement conduct to beliefs. A culture of integrity, ladies and gentlemen, does not just happen. It flows from a resolve to translate right-minded beliefs into reality. Thurgood Marshall was born in Baltimore on July the 2nd, 1908, the son of a railroad porter. And while the boy was growing up, his father frequently read to him sections and provisions directly from the U.S. Constitution. He said Marshall said, when I behaved in grammar school, my teachers made me copy out the entire U.S. Constitution. And from both sources, he recalled, the document's rights and provisions burned into his consciousness, and they stayed there. He was first in his class at Howard University Law School, practiced for a short time privately, and then became general counsel for the NAACP. In the 1930s, he and a small band of staff attorneys began appearing in courthouses in the Deep South, where they entered of record for the criminal defendants, most of whom were African Americans, and thus began the great civil rights litigation that ensued for the next 3 decades. As lead counsel, Marshall became the voice for the voiceless, the destitute, the undereducated, hated and despised, the nobodies and unknowns of this world. And the courts in which he came to their defense were contaminated with bias and prejudice and state-sanctioned racism. For Marshall and his men, private accommodations were unavailable in the Deep South. Public accommodations, they had to find food and lodging wherever they could in private homes and out-of-the-way places, and more than once had to flee in the dead hours of night from angry crowds. But he stood by his convictions dating to his youth. In spite of all threats, all obstructions and impediments, he never wavered, never flinched, never gave in, not once. And he steered 31 cases from the lowest trial courts all the way to Washington, D.C. and the U.S. Supreme Court, where he argued every single one, winning 29, including Brown versus the education. And I don't know whether that's some kind of record or not, but if it isn't, it ought to be. And I ask you, did lawyer Thurgood Marshall have professional integrity? Allow me one more short profile. And I want to contrast Marshall with a promising young lawyer in Seattle, Washington, named Eagle Krogh. That surname is spelled K-R-O-G-H. Some of the older practitioners may remember Krogh. He was in the national news a lot in the 1970s. In 1968, he had a promising career. In 1969, he found himself as a special counsel and assistant on the White House staff of President Nixon. He said, from time to time while working there, we received these plaques and certificates, and they always contained this language: reposing special trust in your integrity. Krogh said, I threw them in the trash can as so much government jargon. He became responsible for a White House unit known as the Plumbers, and their job was to investigate leaks that the president assured him were threats to national security. And the rest of that very unfortunate story is a chapter of the Watergate scandal. And on January the 24th, 1974, Eagle Krogh stood in a court of American law, ladies and gentlemen, and entered pleas of guilty for violating the civil rights of his fellow citizens. He was sentenced and sent to prison, and the Washington State Bar Association promptly levied the ultimate disgrace when it disbarred him. Now, following a long and a difficult and a very expensive and tedious process, Krogh was readmitted, and practices at last count I had of him in Washington, in Seattle, and he also lectures nationwide. And after years of remorse and agonizing over what he had been involved in, he published a book entitled Integrity with this subtitle, Why Good People Make the Wrong Choices. And therein he proffers his observation of what happened in that White House. I'll mention only three. They're universally applicable. He found there was a blind loyalty to the group leader or both. There was a win-at-all-cost mentality, and there was extensive peer pressure to perform and conform as others wanted him to. Professor John Ferrick, who did teach at Rutgers Law School, taught that law practice with integrity is a never-ending task, that it's established and maintained one client, one transaction, one case, one service at a time, and that in the end, it represents the triumph of character. The Reverend Billy Graham preached that if you lose your money, you've really lost nothing. Lose your health, you've lost something. But lose your character, and you have lost everything. And for that proposition, the case of Bud Krogh is unimpeachable proof. In the final chapter of his book, he writes these lines, and I'm going to leave you with these. He writes that whether in public service or private business, each of us is presented with difficulties and opportunities, and integrity shows us how to assess, understand, and appropriately react to them, and with integrity, good people in tough circumstances will make the right choices.